Michaud, may I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Would you state your name for the record, sir?
My name is Frank Michaud. I am the beneficiary of the Frank Anthony Michaud estate that you are administrating over, and I appoint you as the trustee for the record. Let the record show. I am here as making a special appearance, not general. I am here on the grant duress and coercion.
Thank you, Mr. Michaud. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple of preliminary matters.
Before we do that, Mr. Michaud, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of things first before any proceedings.
What is it that you need to get a better understanding of, sir?
For one, is the jurisdiction that the court is operating upon.
Judge, I'm gonna object. The court has made a decision on this motion previously. Both you and Judge Oakley have ruled on this, so I'm gonna object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Michaud make his record.
Yes, ma'am. Okay. Constitution, the 6th Amendment grants me the right to know the nature and the cause of the action.
Today we're back in Judge Green's courtroom for the 4th installment of Frank Michaud saga in what I've been calling the consumed crayons case. This part picks up after 3 previous rounds of confusion, challenges, and jurisdiction, debates that went in circles. Judge Green once again tries to get Frank to focus on the actual charges against him, which include being a felon in possession of a firearm and bringing it to an airport. Despite this serious context, Frank starts the hearing with his usual sovereign citizen-inspired objections about jurisdiction and the nature of the court. Judge Green listens for a bit but reminds him it's a criminal case. She tries to keep things moving, but you can tell her patience is running thin. Frank, meanwhile, seems determined to slow things down with questions about admiralty law and commercial jurisdiction. It's like he's recycling arguments that have failed repeatedly before. The judge keeps her cool but is firm in setting boundaries. Watching this unfold is like watching someone argue with gravity. It just isn't going to change the outcome.
To be criminal, civil criminal. And I also want to, with the basis of that answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off your answer. So.
Mr. Michaud, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.740124 4012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise in a vehicle operated or occupied by said defendant, to wit, a Range Rover. Contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempted to commit a felony, to wit, felon in possession of a firearm. Contrary to MCL 750.227B, there is also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges, indicated to you that this is a criminal matter. The court's question back to you, sir, is: are you prepared to proceed with the exam in this matter?
As the hearing continues, Frank insists he's only making a special appearance and tries to appoint the judge as a trustee. For his estate, this tactic is straight out of the sovereign citizen playbook and has no legal effect, but he's fully committed to it. Judge Green, though, isn't interested in the theatrics. She calmly explains that they're here for a preliminary examination on criminal charges and confirms that the prosecution is ready. Frank claims he needs to understand jurisdiction, ignoring the judge's repeated clarifications. The prosecutor objects, pointing out this question has already been ruled on. Judge Green allows Frank to make a brief record but won't let him derail the entire proceeding. She stays professional, giving him a chance to speak while steering the focus back to the felony charges. It's clear she wants to avoid a circus and move toward a resolution.
Sir, and I will renew that indication to you. Are you prepared to proceed with the exam?
No, because Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a conversation, well, we're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing.
Frank keeps pushing the same question about jurisdiction, despite having been told repeatedly it's criminal. Judge Green explains once more that it's criminal because he was caught as a felon with a firearm at an airport. She clarifies there's nothing civil, commercial, or maritime about it. But Frank keeps asking, as if repeating it will magically change the answer. It's genuinely hard to tell if he doesn't understand or is simply trying to stall. The prosecutor stands ready to proceed while the judge politely but firmly states the court's position. You can sense the court's growing frustration while maintaining a clear commitment to due process. This part of the video really highlights the patience required in dealing with defendants who rely on pseudo-legal arguments. Judge Green shows restraint without letting him hijack the hearing.
You've appeared this afternoon. This case has been called, and if you're prepared to proceed with Mr. Sullivan sitting to your left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15. And the court's, I know, sir, but I'm presuming that there will be some testimony.
Okay, but you're asking me, am I ready to proceed? And you, while you're asking me, you also telling me that we're about to proceed. So you're not actually giving me the right to answer the question. You also making it seem like you're threatening me. So
Mr. Michaud, I'm interrupting you to tell you that I'm not threatening you.
Okay,
but I've answered all that needs to be answered from this court to proceed with either the exam, a waiver.
Okay, all right. But you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to ask?
What's your question, Mr. Michaud?
I just want to ask you, far as, hold on one second. I want to read this for you.
No, sir. You had a question. What is your question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states.
Frank insists on asking if the matter is criminal or civil, even though he's been told clearly it's criminal. Judge Green outlines the specific allegations again: possession by a felon, carrying concealed, and felony firearm, all with clear statutory references. She even details the underlying prior convictions that disqualify him from legal possession. She emphasizes that these are serious felony charges, not minor administrative matters. Despite all this, Frank continues with variations of the same question about jurisdiction. Judge Green responds firmly, pointing out the record clearly shows what this hearing is about. Watching this exchange is like seeing a teacher having to remind a student of the same lesson over and over. It's a masterclass in judicial patience without losing authority.
Last week and just now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, videos, whatever it is that either Mr. Mohammed or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
Okay, so the Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says the prosecuted in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27 Code of Federal Regulations 27 7211. All crimes are commercial. So I still I don't understand.
You were in front of Judge Oakley for a probable cause conference. which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't happen with Judge Oakley. You then had a PCC with Judge Green. Then you were with me for PCC last week. I asked you questions, you wouldn't respond, but I tried to answer your questions. And the people twice demanded an exam. And when you would not answer my questions, I scheduled the exam. Mr. Michaud, your only response right now is yes or no. Are you prepared to proceed with the exam this afternoon?
Well, under threat and
When Judge Green finally presses Frank to choose whether he wants to proceed with the exam, waive it, or adjourn, he continues to argue about jurisdiction. He even mentions being under threat, duress, and coercion, another standard line from these legal theories. He tries to appoint his lawyer as trustee, which Judge Green quickly corrects, pointing out he's his lawyer, not a trustee. She keeps the hearing on track while refusing to humor the nonsense. Frank insists that he's being threatened because he's not getting to ask all his questions. Judge Green reminds him she's answered the relevant ones, but that the court is on a schedule and can't keep revisiting the same issues. This part showcases her ability to balance firmness and fairness in the face of a truly stubborn approach.
Record and Mr. Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion, and it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stempian. And for purposes of this preliminary examination, we'll find that the people have met their burden. And we'll bind Mr. Michaud over as charged. Mr. Michaud, your next appearance date will be on March the 13th, 2024 at 9 a.m. That will be at the Frank Murphy Hall of Justice. Your previously
Frank then tries to cite federal regulations about crimes being commercial and claims there's no injured party, so it can't be criminal. Judge Green patiently explains that those codes have nothing to do with felon in possession firearm charges. She even breaks down how the cited regulation deals with ATF seized property, not this case. Frank protests, saying he needs to understand if this is a commercial crime and claims his rights are being violated. Judge Green reminds him that the court is there to determine if there is probable cause for the criminal charges. To hold a constitutional seminar, it's clear she knows these tactics are meant to delay and confuse, but she refuses to let them derail the purpose of the hearing. Frank raises more questions about facing his accuser and argues there's no injured party. Judge Green clarifies that the accuser in a criminal case is the state itself, represented by the prosecutor. She reminds him that the hearing is to determine probable cause, not to decide final guilt or innocence. She also explains that he'll have a chance to challenge evidence and witnesses at trial if it gets that far. Despite this clear explanation, Frank doubles down, repeating his questions and insisting on the same jurisdiction argument. Judge Green remains polite but firm, refusing to go down that rabbit hole any further. It's a clear example of a judge maintaining control while respecting the defendant's right to be heard. Clip 7, eventually. The court moves to the actual examination phase. Frank's attorney does his job, cross-examines witnesses, and participates professionally, while Frank continues to insist on calling him trustee. Judge Green lets it slide because there's work to do, and the hearing proceeds. After testimony is given, including from a law enforcement officer who details the firearm possession, the judge reviews the evidence carefully. The record of Frank's prior convictions is entered into the record to establish his ineligibility to possess a firearm. This section is less chaotic but shows the importance of having an attorney who can still defend a client despite their unhelpful outbursts. The court listens carefully and gives everyone a fair opportunity to present evidence. Clip 8. At the end of the preliminary hearing, Judge Green announces her ruling. She finds that there is probable cause to believe Frank committed the charged offenses. She accepts the certified record of his felony convictions and the officer's testimony about his firearm possession at the airport. She binds him over to circuit court for trial, setting a date for his next appearance. She also confirms that his existing bond in any conditions will continue until then. Frank doesn't get the dismissal he was hoping for, but he's not remanded to jail immediately. Instead, he leaves with a new court date and another chance to work with his lawyer. The judge handles it professionally and firmly, showing the process works despite the delays. Clip 9. As the video wraps up, the narrator explains that this might be the last we see of Frank for a while, since circuit court proceedings aren't always publicly available. He promises viewers he'll share any updates if they come. He also thanks everyone for watching and encourages them to like, comment, and subscribe for more content. He reflects on how sovereign citizen tactics rarely help and only frustrate the court while delaying the inevitable. It's a good reminder that while you have the right to ask questions, you can't just make up legal rules or redefine criminal court as something it's not. The judge in this case showed real patience while making sure justice continued to move forward despite every obstacle.